In episode 1, we argued that the true origins of competition law reach back to Roman law, but the story does not leap from Rome straight to the Sherman Act of 1890. There is an important legal path in between. During the Middle Ages and the Renaissance, legal systems were already dealing with problems that sound very familiar today: access to markets, exclusive privileges, price manipulation, and restraints on ordinary rivalry. We should not call these rules modern antitrust law, but we should treat them as what they really are: functional and historical antecedents of competition law. The first relevant line is medieval urban market regulation. A good example is the Liber Albus, the London compilation of 1419, that preserves earlier city rules, including material from the late 13th century. In the fishmongers' ordinances, traders were forbidden to buy fish before the proper time, forbidden to go out and intercept fish on its way to market, and forbidden to buy fish from a vessel before it had properly arrived. The text even speaks of protecting the free trade in fish. In simple terms, the law was trying to stop traders from capturing supply before it reached the open market. That is not cartel law in the modern sense, but it is already a legal response to conduct that distorts normal market rivalry. The second line is the common law hostility to monopoly privileges. The leading source is Darcy v. Allen, also known as the case of monopolies, decided in 1602. The court confronted an exclusive patent over playing cards and described it as a plain monopoly patent. But the report goes further. It says that if traders or societies conspire together to enhance the prices of their goods or labor, that conduct is punishable at common law. That is an important idea. It shows an early legal suspicion not only of monopoly, but also of coordinated price increases. At the same time, the report recognizes a narrow justification for a temporary exclusive right when someone introduces a genuinely new trade into the realm for the benefit of the Commonwealth. So even here, the law was already balancing exclusion against public benefit. The third line is statutory, and it appears in the Statute of Monopolies of 1623. The statute declared void grants for the sole buying, selling, making, working, or using of things within the realm, and required such claims to be judged under the common law. But it also preserved a limited exception for patents of up to 14 years for new manufactures granted to the true and first inventor, so long as they were not contrary to law, did not involve raising prices, and did not cause hurt of trade. This is still not modern antitrust legislation. There is no doctrine of cartels, no merger control, and no modern abuse of dominance test. But there is already a clear legal struggle over monopoly, exclusion, price effects, and public harm. So the best conclusion is a careful one. The Middle Ages and the Renaissance did not produce antitrust law in the modern sense, but they did produce something that matters greatly for legal history: early legal instincts against market foreclosure, monopoly privilege, and coordinated price distortion. That is why these materials should be remembered not as modern competition statutes, but as real functional and historical antecedents of the field we now call competition law.